then she no, and then she comes up. She trots up the center aisle to where I'm.
Okay, we are delighted to present our second panel. The second panel is entitled Caring for Elders. Jerry Beyer from the Texas Tech University is the commentator, and we have two co-authored papers that are being presented. Collectively, each paper will have 20 minutes, so 10 minutes. So it'll be a little bit of calisthenics up here as we're running around. The first paper is being presented by Linda Witten, who is a professor at Valparaiso, and Larry Froelich from University of Pittsburgh. And the second is by Tom Galanis from Iowa, and Josephine Gittler, who's also from Iowa.
Thank you. This paper is really part 2 of a project that Larry and I agreed to do for the 3rd National Guardianship Summit, which occurred last week in Salt Lake City, Utah. And our charge was to look at the substituted judgment and best interest standards for surrogate decision-making, specifically in the context of guardian decisions. And as we approached that project, what we realized is that there really had not been any statutory review to determine what the status of surrogate decision-making standards were in guardianship statutes. The literature, we did a pretty exhaustive search of literature and found that there was very little written on these standards in the context of guardianship, much written in the context of end-of-life healthcare decision-making. And there was basically no empirical research that existed in the context of guardianship. So we decided to attack all 3 of those fronts, and unlike a lot of scholarship that we do where we get an idea and then we put together a case for it, we really went back to the old-fashioned research model and said, we don't know what we're going to find, and we're going to go out there in the trenches and dig it up and then see what we'll do with it. So at the time that we put in our proposal for this symposium, we knew we'd find something, but we didn't know exactly at that point yet what all that would be. So what we did find in looking at all of the state adult guardianship statutes and looking to see if there was a general decision-making standard, and we looked for language like expressed desires, personal values, views, etc., that sort of terminology to represent a substituted judgment notion, and then for best interest, really a standard that just clearly directs the guardian to act in the incapacitated person's best interest. We found, somewhat to our surprise, that 28 out of 52 jurisdictions, that includes District of Columbia and the Virgin Islands, 28 jurisdictions have no decision-making standard for guardians. 6 have a best interest, an explicit best interest standard. 4 refer to substituted judgment, but without any mention of best interest. 14 have components of both substituted judgment and best interest, and that's really where the Uniform Guardianship and Protective Proceedings Act, Section 314A, comes in, because this was introduced in the 1997 Act, and from the standpoint of, among those 14 jurisdictions that have a standard that addresses both substituted judgment and best interest, it obviously has been influential. I have italicized the really pertinent language: a guardian in making decisions shall consider the expressed desires and personal values of the ward to the extent known to the guardian, our substituted judgment component, and then a guardian at all times shall act in the ward's best interest and exercise reasonable care, diligence, and prudence. I have at all times in red because as I looked at the state statutes, I found an interesting wording variation, and there are a number of reporters in the room. I was a reporter for the Uniform Power of Attorney Act. We get kind of excited about these nuances in a way that maybe other people can't appreciate. But the red states, Colorado, Kansas, Georgia, Hawaii, and the U.S. Virgin Islands have and I'll just refer to it as the Uniform Act language that you saw on the prior slide. In the yellow states, South Dakota, West Virginia, Virginia, And Massachusetts have that language, but instead of at all times, I'll go back to that slide, a guardian at all times shall act in the ward's best interest, the statute says the guardian shall otherwise act in the ward's best interest. Why is that important? Well, the Uniform Act, in the language as you presently see it, on its face, really gives the guardian a dual mandate. You are to use substituted judgment and at all times act in the best interest. The hierarchy language, or I would argue, hierarchy language, shall otherwise act in the ward's best interest, suggests you use substituted judgment if you can, and if you can't, you use best interest. We have 3 states, Wisconsin, Pennsylvania, and New Jersey, that contain both substituted judgment and best interest components, but do not sort out what relative weight those components are to be given. So we started to wrestle with this and to look at, well, is this really a clear, practical standard for guardians? For example, if you say use substituted judgment if you can, and if not, use best interest, what if substituted judgment leads you to a completely unreasonable result, or worse than unreasonable, substantial harm? If you say use substituted judgment and at all times act in best interest, well, what if the incapacitated person had left directions for something that's reasonable, but might not stand up to a best interest evaluation? You know, what's a guardian supposed to do? So that's really the subject of our paper. For this symposium, we're going to make a proposal for reform, but before we talk about that, as a part of our project and looking at the literature on the different decision-making standards that make up this whole area of surrogate decision-making, substituted judgment, best interest, we mined from that different opinions and approaches and have given some labels to those and put together a model, and Larry is going to talk about that.
First of all, both Linda and I want to thank the sponsor organizers for all your work and efforts for this really great conference, and a special shout out to the Law Review for being willing to publish these papers as a symposium. It would be very effective that way. Papers are, you get a lot more bang for your buck when you write an article, particularly when you're surrounded by a lot of other bright people. So even if you're not so bright, at least in my case, you look a lot better at the end of the day. So, well, here we go. Let's see if I can make this happen. Oh, it worked. Okay. First of all, we found about 4 different ways you could break down how guardians make decisions. Now, we start from the assumption, incidentally, and I think this is a correct assumption, that guardianship is supposed to promote autonomy and individual dignity of the individual under the guardianship, the person under guardianship. And so the substitute judgment is the favored model where it seems to fit, particularly where autonomy issues are most prevalent, and that's in end-of-life decision-making. We've now gotten to the point in the law where at end-of-life decision-making, courts almost always at least talk about substitute judgment. My favorite one is a Pennsylvania case, the Fiore case, where they could find nothing but, quote, the person's lifestyle as giving adequate support for substitute judgment. So we know that's an extreme end. But so today we're focusing less on end of life as you move away from that, from things like residential decisions and property management, where substitute judgment has not won the day as clearly as it has at end of life. So let's go through these: the strict, expanded, et cetera. Strict substitute judgment decisions should be based on prior specific directions. This works well in end-of-life care to some extent, because you can have a document that says no tube feeding. Okay, that's pretty straightforward. Although, of course, we know you quickly move away from those black and white decisions to very murky things. But outside of that area, it's much harder to ever find the kind of decision where you can say, I know for a fact this is what the person wants. But I'll give you an example. Suppose you have someone, an older woman who's entering into dementia, and she says to her family about her summer home in the Upper Peninsula, never sell that home. I want that to be available to keep the family together after I die. For whatever reason, she doesn't commit this, doesn't appoint an agent. She gets more demented. She's never going to use that summer home, okay? And it's a costly thing to keep up, so maintenance, et cetera, taxes. But she has a pretty good-sized estate. And the estate can bear the costs in the sense that if you can project out her future financial needs, you can afford it, as it were. Guardian should continue to maintain that house because that's what she wanted. You have specific instructions to that effect. But that's pretty unusual. You're not going to find that in most cases. And if you read the case law, which gives a nod to substitute judgment, they don't really rely on specific judgment statements. They rely upon what we would call expanded substitute judgment, where you're getting more broad statements. You could have, for example, someone saying, I'd like to keep that house in the family if that's what the kids want, type of thing. Same summer home, but now we don't have an explicit directive, but we have a certain values indicated. Or she may have never said anything specifically, but may have said many times, this house is really important because it keeps us together. And so you'd have to translate from those kind of general statements that she wanted the house to be kept. Of course, we're now getting into murky areas because she might have said things that went the other way, right? And so you would have to make some sense of these general decisions. But this is where you're going to go in most cases. You're going to go to a very broad statement of values, customs, statements, and so forth. And we already do this in healthcare, end of life. Where do you get most of end-of-life statements from people about how they want to be treated? When they're watching House on TV, the movie, and they turn to the person next to them and say, I hope that never, don't let them do that to me, right? That's about where you get, and that is, of course, valid information about how a person might want to be treated. And so expanded substitute judgment is really necessary if we're going to allow a person's wishes and desires to continue to govern their person and property after they have become unable to do it themselves. But at some point, you really, even lifestyle isn't going to give you much, you're really kind of just using the words. And interestingly enough, when you read cases, courts will use the word substitute judgment, and they're clearly doing best interest. But that's okay, because they'll use best interest when they're clearly doing substitute judgment. One of the things we have not been able to succeed in law reform is to get judges to understand what those terms mean and apply them on any consistent basis. And I think the reason for that is that different judges have different sense of what's the right thing to do. Some think the best interest, well, that's what I'm supposed to do. This is a person under guardianship. I'm supposed to watch out for them. That's my main, what should guide me. And others, of course, are more tuned to substitute judgment language. And so they use the same different words to get the same outcome, essentially. But it causes a lot of confusion. But best interest, if you take it narrowly, and if you look at the cases, it means an objective observer. What would someone, here's a guy named Mike Osmond over here. I'm sure he's a great guy. I know nothing about Mike Osmond. And if I had to make decisions for Mike, I would have to say, well, what would Mike, as a reasonable person, do? What would be best for Mike, knowing nothing at all about Mike, okay? That's the John Doe, Jane Doe problem. There are very few Mike Osmonds and Larry Froelich relationships in this world in terms of guardian. I'm unlikely ever to be Mike's guardian. So in most cases, the guardian knows something about the person, or they can learn something about the person by going back to the community. And you can find out things. You can find out, was religion important to them? If so, what are those religious tenets? What were their attitude about saving money for the children as opposed to living well in their own later years? What are their attitudes about where they might want to be housed in case they are unable to care for themselves? These priorities, it's really a blend. You pick up some substitute judgment, but not enough really to tell you, to make you sure that you know what the person wanted, or even with a straight face, you can say that, but you don't really believe it. But if you inject some substitute judgment into best interest, not for the unknown Mikes of the world, but people that you might know. I know Linda better, not everything about her, but if I was doing best interest for her, I could weave it into the life that I know, or Gary's life, to the extent I know Gary, which is less. All right, so that's our 4 models, and the strict best interest is the standard one. As I say, this seems to me a model you shouldn't have to use very often. This is the unbefriended elderly person, the John Doe that comes in, you know nothing about them. But guardians shouldn't be allowed to say, oh, I don't know much about this person, I'll just do what's best for them. They should be encouraged to go back, talk to other people about this person, get some sense of the person, And you might even get back to expanded substitute judgment, right? As you move from, I don't know anything about this person, to a little bit of investigation, you can get much closer to some kind of substitute judgment. But you won't get there unless that's what you're told you have to do. Now, we put together this very easy, handy model, which, of course, it's really not that complicated. Simply think of a rainbow. And you're moving from one side of the rainbow, you know, I can't remember my rainbow colors on the end, so maybe it's not a rainbow. Just think of a continuum, that's a little easier, from left to right. And you start with strict substitute judgment. If you know that, you do exactly what they say. And the far end, you get to strict John Doe, strict best interest. And you're moving across that continuum. And we have boxes, but of course, in reality, there's no sharp division. You simply are gradually moving away from feeling comfortable about knowing what the other person would have done to eventually getting to the point you're saying, I'm trying to do what I think they would have done, but I'm not really sure about that. The information is pretty fragmentary, or this decision is so far away from anything they ever talked about or expressed an interest in, I'm not certain I'm really following their interest. But that's how you move across. Now, under the boxes beneath this unreasonable result come back to the concept that a guardianship is a court-appointed relationship, and the court is ultimately responsible for the well-being of the person under the guardianship. And courts should not, and guardians should not, do things which are destructive to, stupid, or silly for the person under the guardianship. At some point you say, we're just not going to do that. Our little example is a woman, a person who owns a 1954 T-Bird convertible classic model, great car, and drives it. And she's becoming demented. She says, you know, don't ever sell that car. My kids are going to love that car. You know, they're going to want it. And then it goes into dementia and no longer can do anything. And the kids come forward and say, the last thing we want is a 54, you know, convertible. I want my good van with lots of cup holders and things. I don't want an FM radio in the car because you didn't have FM. So they don't want the car. So at this point, it's, quote, stupid, silly, or unreasonable to keep the cost of the car housed and maintained and all that kind of thing. You could sell the car even though it's clearly transgressive of her wishes. The exception, of course, is unreasonable decisions that arise particularly from religious beliefs. And the classic case is that Jehovah's Witnesses, no blood transfusions, therefore no operations. Almost by definition, religion's beliefs are not based in reason, right? They're based in faith. So it's silly to talk about it. It's a reasonable decision. The decision can be reasonable after you get past the initial assumption. It's reasonable within the value structure. But you don't impose blood transfusions upon mentally disabled, mentally incapacitated Jehovah's Witnesses because that would be, even though it might be reasonable, it's unreasonable given their fundamental belief. But that's one of the few cases where it's clear that what might be seen as destructive nevertheless would have to be action the guardian would go forward on. Now, caveat, guardians, of course, can always go to the courts to get backup on this or guidance. So you're not going to leave it. The guardians are not out there on their own. They should look for instructions when they believe they have to follow the wishes of the person, but that seems to be a bad idea. Thank you.
Oh, there's more, but only a little more. Okay. To translate the model into statutory reform, what we're proposing is a revision to 314A, and you have handouts in front of you. It might be easier to see that on the screen, but you know, one of the insertions we have on the fourth line, a guardian shall promote the self-determination of the ward. A self-determination doesn't appear in the express language of current section 314A. The last sentence picks up the phraseology that currently exists in the statute, exercise reasonable care, diligence, and prudence, and in making decisions, takes the guardian through these three steps, which really relate to what we were calling in the model strict substituted judgment, expanded substituted judgment, and expanded best interest. So you act in accordance with the ward's reasonable, current, or prior directions, express desires and opinions to the extent they're actually known or ascertainable, so thus promoting an attempt to ascertain these views, and also promoting the notion which the 1997 Act promoted, that you should try to have current conversations with someone with diminished capacity. But that also argues for the importance of a reasonableness filter in terms of, what you actually do based on that information. If you don't have that, you go to the second tier, reasonable prior general statements, actions, values, and preferences. And if you don't have those, then you're into that expanded best interest notion. Now, in addition to the need to give guidance to guardians, in terms of the UPC and the other statutes in which we have a surrogate decision-making standard, a revision along these lines would harmonize the surrogate decision-making standard with that currently appears in the Uniform Healthcare Decisions Act and also the Uniform Power of Attorney Act, which is you move from directions if you know them, and in the case of the Uniform Power of Attorney Act, reasonable expectations if they're actually known, otherwise best interest. I should add a note that at the Guardianship Summit last week, there was a vote by the delegation to recommend that states adopt a decision-making standard that incorporates both substituted judgment and best interest principles, that the priority be given to substituted judgment and self-determination, and that the Uniform Act be revised to do that. So we're going to amend the title of our article. It's no longer theoretical aspirations and practical complications. It's going to be a proposal for reform. So thank you.
Professor Gittler and I would like to thank the ACTEC Foundation and the Journal of Law Reform for supporting this symposium, and to thank all of the organizers, both the faculty organizers and the student organizers, for putting this wonderful event together. I would also like to say a special word of recognition and gratitude to two of my former mentors and teachers, Larry Wagoner and John Langbein, for their inspiring work in law reform, which has been a model for me and for so many others in the room. It's particularly fitting to hold this event at Michigan to celebrate all of Larry's achievements and contributions. Together, Larry and John really have remade American succession law. The paper that Professor Gittler and I are presenting today is entitled Family Caregiving in the Law of Succession. As the American population ages, the need for family caregiving, which is already great, will become even greater. Our public policy and law must do more to support caregiving within the family. Now, much of this work will be done by areas of law other than the law of succession. But in this article, Professor Gittler and I address the following question. Is there a way that the American law of succession can recognize and promote family caregiving? Current succession law, we argue, is not the regime best designed to achieve this purpose. The current law amended by our reform proposal, Protection of a Family Caregiver, modeled partly on a spousal elective share, will do a better job of recognizing and promoting the family caregiving needed by the elderly and disabled. Our article is divided into 3 parts. In this presentation, we're going to focus on parts 1 and 3. Professor Gittler will present part 1 on the aging of the population and the need for and contribution of family caregiving. Then I will present part 3 on our proposal and how it might be structured.
Well, as Tom has indicated, the genesis of our proposal arises out of 2 phenomena, 2 developments: the aging of the American population and the contribution that families are making to meet the care needs of their older relatives. And I'm just going to very briefly describe those 2 phenomena, those 2 developments, so that you understand whence our proposal comes from. The aging population. The population of older persons, by which I mean 65 years and up, is large and growing. In 2009, the number of persons 65 and up was nearly 40 million, or nearly 13% of the total population. Now it's projected that from 2010 to 2050, that population is going to nearly double. And the population of older persons, the oldest old, 85 and up, it is projected will nearly triple. Why is the population aging? Well, one reason the population is aging is because there has been a dramatic increase in average life expectancy. But the overwhelming reason the population is projected to grow as much as it is projected is the baby boomers, those born between 1946 and 1964, of which generation I am a member, and I think some people in this room from looking at them are also members. They're coming. Actually, they've started coming. This year, the first baby boomers turn 65. And they're going to create a tremendous demand for services and support, including family caregiving. Why? Well, because most older persons have at least one chronic disease, physical disabilities increase with age, and older persons, particularly the oldest old, 85 and up, are at risk for Alzheimer's disease and other dementias. Individuals who reach 85 have an almost 50% chance of having Alzheimer's disease or some other dementia. And remember, I just told you what? I just told you that from 2010 to 2050, it's projected that the population of oldest old is going to triple. As a result of chronic disease and disabilities, a substantial proportion of the aging population, again, especially the oldest old, have functional and cognitive limitations. And that means that they may well have an inability to perform or difficulty in performing activities of daily living or instrumental activities of daily living. And that leads, among older persons, to a need for long-term care. An estimated 70% of persons 65 and up will need long-term care at some time during the duration of their life for an average of 3 years. Persons 85 and up are 4 more times likely than others to need long-term care. What do I mean by long-term care? That term covers a wide range of services and supports. It may be home-based, it may be community-based, it may be facility or institutionally based. And that brings me to family caregiving. Informal, unpaid family caregiving is the most important source of long-term care for older persons. An estimated 1 in 6 adults provide unpaid long-term care to older adult relatives or friends, predominantly relatives. And it's estimated that in 2009, there were roughly anywhere from 55 million to, 69 million caregivers providing care to older adult family members. The family caregiver typically furnishes assistance to an older relative with activities of daily living and instrumental activities of daily living. The typical family caregiver is a woman, age 49, employed outside the home, providing care to her widowed mother. The burden of family caregiving, and this is important to our proposal, can be considerable. A 2009 national survey found that over 50% of caregivers reported a medium to high level of burden. Family caregiving can have detrimental economic consequences. The caregiving often has negative impact on employment status. The family caregiver may have to stop work, may have to work part-time, may have to cut back on their hours of work, etc. And that means lost earnings, diminished Social Security, pension benefits, diminished retirement savings. Moreover, caregivers frequently incur out-of-pocket expenses that are significant, at least as significant to them in terms of their income in connection with caregiving. And family caregiving can have detrimental health and psychosocial consequences. Caregivers are more likely to have poorer physical and mental health than non-caregivers, and caregiving may adversely affect a caregiver's relationship with other members of the family, spouse, children, and may lead to his or her social isolation. The economic value, and this is also very important to our proposal, the economic value of informal unpaid family caregiving is enormous, as you can see. Estimates of the economic value of unpaid family caregiving in 2009 ranged from $199 billion to $450 billion. Now, while the bulk of long-term care to older persons is provided by family caregivers, formal paid caregivers also provide care to the aging population. It's expensive. The main sources of financing for formal paid care in order of importance are the federal state Medicaid program, the federal Medicare program, out-of-pocket expenditures by the care recipient, and private long-term care insurance. And I want to focus in on this because this has implications for our proposal. The federal state Medicaid program is the single largest source of funding for formal paid long-term care. It accounts for nearly 40% of long-term care expenditures. Traditionally, Medicaid paid primarily for nursing home care. It still is the primary public and private payer of nursing home care, although the institutional bias of Medicaid is shifting, and it's now paying for more home and community-based care. Long-term care is a major component of the Medicaid program, which is funded with both state dollars and federal dollars. And it's growing at annual rates that exceed state revenues and national economic growth. I like to tell people this because I think it really brings home that statement. In 2010, it is projected, when all the figures are in, that aggregate state spending on Medicaid, and just state spending, not even including the federal spending, will exceed the aggregate state spending on K through 12 education. So, the rationale for our proposal, which Tom is going to describe in more detail, is that public policy and law should recognize and support the contribution that families make to meeting the existing and growing need for long-term care of the older population, of the aging population. And that without paid family care, already strained state and federal budgets would have to increase enormously to cover the costs of long-term care. It would really be unsustainable. So there is a very strong governmental interest in encouraging and supporting family caregiving. Tom?
I'll now present part 3 of our paper, in which we explain our proposal and place it within its scholarly and legal context. And here I'll begin by giving a shout out to my friend Professor Joshua Tate, who wrote an article a few years ago, a very good article, on caregiving and the case for testamentary freedom, in which he compared the American tradition of testamentary freedom to 2 of its international alternatives, the family maintenance systems in England and the Commonwealth, and the forced heirship regimes in Louisiana and continental Europe. Professor Tate argued that the American tradition of testamentary freedom has a modern justification, namely the promotion and reward of caregiving within the family. We agree that the law of succession should encourage family members to provide care for elderly and infirm parents and relatives, but we're not certain that the traditional American approach to the law of succession, here meaning unfettered donative freedom, is the one best suited to support and promote family caregiving. Now, some scholars, most recently Professor Francis Foster, have argued for a behavior-based approach to succession, focusing on the facts and circumstances of one's conduct toward the decedent. Professor Foster draws on her knowledge of the behavior-based law of succession in China, designed in part to encourage the care of one's parents and elders. There are other scholars who tout the benefits of the family maintenance system in use in England and many parts of the Commonwealth. However, we are realists. Reforms of the American law of succession are most effectively realized through the Uniform Law Commission and its Uniform Probate Code. The UPC has been in recent decades the most prominent vehicle of innovation in American succession law. And that's why we think working within the Commission's process of law reform is so important. Any plan radically to restructure the American law of succession into a behavior-based model, or alternatively into an English-style family maintenance system, we think would be a dead letter. So our task in this article is to devise a proposal to amend the UPC in order to recognize and promote caregiving within the family. And in so doing, we're mindful of the fundamental structure of American succession law, and specifically the law's two core features: an emphasis on fixed rules over judicial discretion, and a deep commitment to donative freedom. Donative freedom is not unfettered, however. The decedent's obligations have priority over the decedent's whims. Moreover, American succession law protects at least one member of the decedent's family against disinheritance at the decedent's whim, namely the surviving spouse. These observations lead us to a proposal for amending the UPC to contribute to the overarching goal of recognizing and encouraging caregiving within the family. Why not enable a family member who provided the decedent with substantial, uncompensated care in a family residence to elect some share of the decedent's estate? In this context, a family member means an individual other than the surviving spouse, because the UPC already provides a spousal elective share. Our approach contrasts with the prevailing law in the US, which views personal services rendered by family members as gratuitous, hence not compensable. The scope and amount of the caregiver's elective share can be structured by partial analogy to the surviving spouse's elective share, though with important differences. What might such a proposal look like? I'm an inveterate tinkerer, and so you have the latest draft of sample statutory language on the handout. That's where it currently stands, but it's a bit of a moving target. 5 features of the draft statute should be noticed. First, the statute is directed at family caregiving. This accords with the emphasis in the UPC and in American succession law generally on the family unit. We recognize that friends and neighbors can and do provide uncompensated care, but the burden of such caregiving is borne primarily by family members. They are the focus of the statute. Second, but connected with the first, the definition of who counts as a family member is designed to be as broad as feasible while remaining largely consistent with the thrust of other UPC provisions. So the statute defines family member as a grandparent, descendant of a grandparent, or stepchild of the decedent. This is as broad as the UPC's provisions on anti-lapse for wills and certain non-probate transfers, and slightly more expansive than the UPC's provisions on intestacy. Also applicable to the definition of family member are the UPC's thoughtful and up-to-date provisions on the definition of parent and child, including the 2008 and 2010 amendments covering children of assisted reproduction. Third, the statute is crafted by partial analogy to the surviving spouse's elective share. An alternative reform which we rejected would have been simply to repeal the presumption that family care is rendered gratuitously, thus opening the door to such claims being made against the decedent's estate. Such a market-oriented view in which the decedent and the family member are treated as fundamentally economic actors has a serious downside. It does not recognize and indeed may corrode the love and affection between family members that the law of succession should reflect and encourage. The draft statute aims to recognize and support caregiving without substituting economic self-interest for love and affection as the motivating impulses. Spouses care for each other for reasons independent of, and indeed bolstered by, the spousal elective share. In the same way, we hope and expect family members to continue to care for each other for reasons of, but bolstered by, this elective share. Fourth, the draft statute requires the family member to have provided substantial uncompensated care in a family residence to the decedent for a specified minimum time. In the draft, at least 1 year out of the 2 years preceding the decedent's death, to allow for some episodes of hospitalization or skilled nursing care, or, at the end of life, hospice care. Words such as substantial cannot be applied mechanically. To help avoid problems of evidence, to limit the extent of judicial discretion, and to reduce the likelihood of an attempted unjustified claim, the statute requires the family member to establish the entitlement to an elective share by clear and convincing evidence. The UPC currently takes a similar approach to potentially difficult matters of proof in its provisions on survival and harmless error. Fifth, the architecture of the family caregiver's elective share is modeled somewhat on the innovative structure of the UPC's spousal elective share. The caregiver share, akin to the spouse's, applies to the decedent's probate and non-probate transfers alike, in accord with the UPC's policy and practice of applying the same substantive rules to wills and will substitutes. And just as the spouse's share increases with the duration of the marriage, the amount of the caregiver's share increases on a per-month basis to reflect the duration of care provided, but in no case more than a quarter of the augmented estate. Our law and public policy must grapple with the aging of the population. The need for long-term care is urgent now and growing more urgent each year. The law of succession cannot, by itself, solve the problem, but it can contribute to a solution by recognizing and promoting family caregiving. I want to close by emphasizing that the aim of the statute, like the spouse's elective share, is to a significant degree expressive, to express and reinforce a norm. In an ideal world, the spouse would never need to elect a share, and the presence itself of the elective share statute helps to reduce the need to use it. The same here. Our aim with this statute is to reinforce the norms of caregiving within the family. Once we have our statute in final form and publish our article, we encourage the Uniform Law Commission and state legislatures to consider this proposal. As I've said, I'm an inveterate tinkerer, and apologies to our commentator who has had to try to keep up with my changing the statute. Every time I think of an objection, I try to modify the statute accordingly. If there are further objections, I'll try to keep amending the statute. So feedback both from Professor Beyer and from members of the audience, this is why I gave you the text of the statute, would be most helpful. All feedback is welcome.
All right, good morning, everybody. My name is Jerry Beyer, and I am very honored to have been asked to comment on these very interesting presentations. Now, I know that their articles were not available in draft form yet for you to read, but I certainly do recommend that when they are published, that you do read them. Both articles are extremely well written and researched, and I think you will find them to be most interesting. Well, let's start then by placing these two articles into perspective. Each presentation focused on a way to enhance the care of older members of our society. And without doubt, this is a laudable goal. And of course, as we get older ourselves, this topic begins to have a personal, as opposed to merely academic, import. Now, we have heard two very different approaches to achieve this goal. First, we heard a well-reasoned, incremental, and logical extension of existing law. And second, a radical and, in my opinion, seriously problematic, at least in its existing form, solution to the problem. What I'd like to do now is look at each of these and why I have reached the conclusion that I have. Now, I've tried to keep my comments brief so that the audience will have a chance to ask questions and that the speakers will be able to respond as well. Let's start first with Professor Witten and Froehlich's substituted judgment article. They began by explaining that the prevailing standards that have been used to guide the judgment or guide the guardian in making decisions for the ward have been, in many states, no standard, and then a best interest and substituted judgment standard. So we have these two standards, the best interest and substituted judgment standard, in conflict. And I agree with them that these two standards are indeed in conflict. And the current language of the Uniform Guardian and Protective Proceedings Act and its dual mandate is unworkable, because it requires all substituted judgment actions to be in the ward's best interest. And we all know that when we are competent, we do things not in our best interest all the time. Listen to the things we do. We drink alcohol. Some of us smoke. Some of us use recreational pharmaceuticals. Some of us will eat fatty foods. We'll go home and watch reality TV. We drive too fast, and we get angry at our partners. Yet few of us would think that anyone has the right to stop us from doing these things, except maybe the recreational pharmaceuticals and speeding, because that's illegal, even though it's not in our best interest, because they are what we want to do. And I don't see any reason, other than in situations where it would be excessively unreasonable, to deny that right to somebody merely because they have gotten older or disabled and need a guardian's care. Now, like I said, it's true that while competent, a person has the ability to do really harmful things to him or herself if they want. For example, you could decide every day that you're going to bang your head against the cement wall because, you know, after a half hour and when you stop, it really does feel good. But I don't know from personal experience about that. I just heard that. But you cannot expect a guardian to act in any type of outrageous, foolish, or irresponsible manner. And therefore, you can see that Larry and Linda's approach of placing substituted judgment and best interest on a continuum makes a tremendous amount of sense. I mean, you start off following specific directions that the ward left behind where you know exactly what they want to do. If those aren't available, then you blend into looking at the person's activities, their values, their general statements, like the example you made, watching House on TV. And all of that then helps the guardian make the decision that the ward would have made had the ward still been competent. And then, if you do not have that type of information, you transition into doing what would be in the ward's best interest, like when Larry mentioned what he would do for Mark over here, even though they are not aware of each other's needs, interests, values, etc. at the moment. And so I think that the bottom line of all of this is that their four-step sort of continuum approach would closely approximate what the person would have wanted. I think it's probably the best proposal to approximate someone's desires that I have seen. And thus, I definitely join with Larry and Linda, urging the enactment of their suggested language, the Section 314A. Now, let's turn our attention to Tom and Josie's family caregiver solution. Now, what? All right. Now, the problem that they identify is indeed very real. There will be an ever-growing number of older people who need assistance. And it is also true that family members will often take the lead in providing care, and that this provision comes with a great economic and emotional cost. I'll bet you I could ask how many of you here have been involved with the care of an elderly parent or grandparent. I see, for those of you watching on video, at least a third of the people in the room raise their hands. So it's obvious that this is a situation of great financial, emotional, etc. concern. However, providing a forced share for a family caregiver is, in my opinion, not really the way to solve the problem, at least not until the concerns that I'm going to raise are addressed. Now, as my friend Tom mentioned, he has been tinkering with the statute. And my number one concern, and I didn't talk to him about it, he just sent this to me on his own, was fixed. So I'm going to tell you about the concern anyways, just in case you get a hold, just in case you get a hold of an old draft. Because it was my best point. All right. And the way the draft originally read is that rather than getting a fixed amount of money per month of uncompensated caregiving, as the proposal now reads, it was just a percentage, a sliding percentage of the estate. So that if you took care of someone for 1 year and they were Warren Buffett, you'd walk away with a huge windfall of a huge percentage of the estate in dollar amount. But if you provided care for someone who was less wealthy, you wouldn't get anything. But that was changed. Now he has inserted a number. And now your number was $1,500 a month.
In brackets.
In brackets. And that being in brackets made me feel good. Because if you do such a proposal, which I'm not saying, there's two ways you look at this. First of all, don't do it. And then if you're going to do it, you got to fix it and make it as least bad as possible. But if you put an amount in there, I think your amount is way too low because that is not in any way equivalent to the costs that Josie put on the screen of what the cost would be if you went out in the outside world and hired somebody to do it. All right. Now, another thing that concerns me about your proposal is that it only rewards unsuccessful caregiving. Every one of the people who are going to get your forced share took care of someone until they died. So if someone needs caregiving and they get good care and they recover, and now in the last couple of years of life they don't need you, no forced share. So in effect, the forced share becomes a reward for caring for the person to such an extent that they die. Okay. Now, another concern I had with the forced share is why you're only picking on end of life. Because you see, I think the same logic should be allowed for a parent to elect a forced share when a child dies to recoup 18 years, at least, of expense, lost opportunities, turmoil that they went through. Why is caring for the older person meritorious of a forced share, but caring for a child not worth a forced share? The inequities of beginning and end of life are somewhat concerning to me. Now, although some of you may think that's a little on the humorous side, I want to talk about one that's a little more serious, and that is how it really works in the world with family caregiving. Many times, the older person will move into the house where the caregivers live. Maybe we have a son, daughter-in-law, the son's wife, and maybe some grandchildren, the children of the son and daughter-in-law taking care of the child. Under the proposal, none of these people might qualify for the forced share. The son may be the one who doesn't provide the substantial amount of care. The daughter-in-law may provide the substantial amount of care, but the way I read your definition, a daughter-in-law would not fit into the definition of a family member. And therefore, here could be a situation where you have a son, a daughter-in-law, and grandchildren providing all the support, doing a wonderful job, and yet none of them would qualify for the elective share. Now, for some of the purists of testamentary freedom, you can see that this proposal erodes testamentary freedom. I mean, already, testamentary freedom is eroded by a forced share for the surviving spouse, which can be 50% of the estate. And remember, that's not just 50% of the marital assets, but it could be 50% of all the non-marital assets that one of the spouses brought into the marriage. if you tack on this, which you said was limited to 25%, I believe, that could be 75% forced share tax in effect on the estate, leaving only testamentary freedom for 25% of a person's estate in a worst-case scenario. Now, this was a note I made while I was listening to you, and I can't quite read what I wrote. Oh, yes, this was it. You said uncompensated family caregiving. Now, sometimes the situation is as I described, where the person who needs assistance moves in with the caregiver. However, I have also seen situations where the family member who provides the care moves into the person who needs the care's house. So the child moves back into the parent's house and provides the caregiving services. And maybe they're not compensated monetarily, but they have free room, board, electric, cable, telephone, maybe even food. So I was concerned whether that would be taken into account. And I'm also was concerned about the problems that were discussed during our earlier presentation about judges who are untrained in this area making decisions over what substantial care is. And what I could see is a situation where you have an older parent and a brother and sister who both want to work together to take care of the older parent, but now they realize to get the forced share, they got to compete. One of them has to be the primary caregiver to get the care, because otherwise neither will get the forced share. So one of them has to win. And I thought that kind of controversy may cause family members to compete rather than to cooperate. Maybe a proposal where they could share a forced share. But like I said earlier, although these are the different things I pointed out, and I'm sure, Tom, as you're scribbling away your notes there,
you will draft it, yes.
You will, there you go. You will fix some of these problems. And I think the goal is extremely laudable. However, I still question solving the problem with a forced share provision. But what else do we do? Well, you mentioned in your paper, I don't know if you talked much about it, but there is a procedure in Illinois where there is a statute that provides for a family caregiving fee of some sort, I guess you might want to call it. Now, it's relatively new, and there's very little experience, especially any kind of objective studies to see how that statute operates. I will be very interested to see how that statute operates, and maybe that would be something to investigate. And then, of course, you know, if you have a problem, it needs to be solved. So I was trying to think, is there any way that I would try to solve this problem if this elective share provision is not the way to do it? And here's what I thought of. It's not very original, and I'm not sure it would work, but what I would do is perhaps amend the power of attorney statutes and amend guardian statutes and expressly provide that by default an agent or guardian has the right to hire a family member as a caregiver on mutually agreeable terms to provide caregiving services. So that right up front, you have an agent paying or a guardian paying for the caregiving services. Or if you say, well, maybe they're just going to be rendered out of love and affection, then up front, they sign a waiver that they're going to get this. So rather than trying to move the determination of how much a person is entitled to the back end, meaning basically after the person has died, move it up front and make people make a determination there upon guardianship, or if there's a power of attorney on what to do. Of course, the big problem there is that with family caregiving, there might be many situations that this can be done to avoid the need for a guardianship or even a power of attorney in some circumstances. So in conclusion, I definitely agree with Tom and Josie that something needs to be done to encourage family caregiving. I'm just not sure how to do it, and I'm not sure whether a forced share is the approach for the Uniform Probate Code to adopt. All right, so how much time we have for questions and things?
20 minutes.
All right, questions, comments, responses?
Can the members of the panel respond?
Yes, Let the members of the panel respond.
Sure. First, I want to thank Jerry for his commentary. I view this as kind of like the first reading of a statute at the Uniform Law Commission process. All Uniform Law Acts have to go through at least 2 readings. So many of these points are very, very helpful. And I'm heartened by, in fact, that some of the comments that Jerry made suggest that the statute doesn't go far enough. I just want to thank Jerry. I've taken all of these notes. I think I can pretty much address most of them in the statute itself. The one that I probably can't is his question about the curmudgeon decedent who cuts out both the spouse and the caregiver, and in such a case, after a long-term marriage, the combination of the elective shares is 75% of the estate. I'm not sure that I have much sympathy for that curmudgeon. But all of the other points I think are well taken, and we will work to address them in the statute 2.0.
Well, I thank Gary for his wisdom perceiving how good a proposal we had. I always knew he's a bright guy. 2 additional points. We, of course, here, when we think about guardianship, the model is an elderly person. But of course, there are 2 other major populations for whom guardians are needed, and so the same law applies to everybody. One is people with mental illness. The problem there, of course, is the person may come in and out of capacity as that's defined, or even when they are in a state of incapacity, they often have strong opinions about how they would like their person or property to be dealt with. And they can express them, and their desires may or may not arise out of the mental illness. That's a very difficult question. The other population are people with developmental disabilities. And there the model, of course, is to try to get people with developmental disabilities to participate as much as possible in their life decisions, and with the recognition that, in fact, the more you help them to participate in decisions, the better they will do in the future. So you want to reinforce their involvement. And both those argue for a strong substitute judgment model, because with the persons with mental illness, in fact, if you look at the old law, one of the reasons the guardians were limited on what they could do was the fear that the person would regain capacity and wonder, what did you do with my property? That was the old case law to that effect. And now it's true. You could have people who were under severe disability for a while and then later, thanks to modern medicine, regain capacity. So while they are in that incapacitated state, or legally, and you want them to be involved in decisions, revolving around housing and where they live and how their money is spent. So if they are able later to regain more control of their life, you haven't done something that they would go, what were you doing? Why did you do that to me? And of course, with the developmentally disabled population, we want those persons to be able to have autonomy to the extent feasible, and that means they need to participate in these decisions. So in all these cases, the elderly, mentally ill, developmentally disabled, we want to push guardians to the concept that your duty here is to try to help that person engage what they want, keep their lives as normal as possible in the sense of what they're doing, rather than you can do what you think is best. We have to push people away from that. That's a very human instinct. I'm going to do what's best for this other person. Okay? And rather than doing that, we need to have the law, and again, goes back to what we've been talking about all morning, how the law is suggestive and aspirational. And so I think it is important that the code flag this importance of doing what the person under the guardianship might have wanted done, if you can ascertain that, and you have a duty to try to ascertain that.
Yeah, just one other comment. We didn't really have time today to talk about the empirical research that we did for the Guardianship Summit project, but we did a guardian survey about what guardians consider, what factors they consider when making financial decisions, and we did a separate set of questions for healthcare decisions, and we distributed surveys in a state that really had no standard, but is, through case law is a best interest state, and then we also distributed surveys in South Dakota, Georgia, and Massachusetts, which have some combination of the substituted judgment best interest standard. What was interesting, we subjected our results to a parametric statistical analysis, and there were very statistically significant differences from these groups.
And the substituted judgment best interest states there was more of an effort to rely on current conversations and what other people told the guardian about the values and the preferences of the person. In the no standard best interest state, there was heavier reliance on the views of family, family harmony and consensus, and what the guardian would want if the guardian was in the incapacitated person's position. So, I mean, this suggests that a standard matters and that a statutory standard can help form the culture for surrogate decision-making in a jurisdiction.
Thank you for the presentations. I have a question for Tom and Josephine. One of your slides showed that the average caregiver was a 49-year-old woman who's employed and so on. We also know that the typical elder abuser is the 45 to 50-year-old son who is unemployed and usually drugs are involved. He moves into the mom's house because the siblings figure, well, he's sort of the loser, he doesn't have a job, he might as well take care of mom, and then empties her bank accounts. Now, I realize your proposal could deal with this by saying, well, if you commit elder abuse or neglect, you know, you don't get anything. With this paradigm, though, there usually isn't anything when the mom dies because the loser son has already emptied the bank accounts. And I'm trying to figure out if your proposal would exacerbate that problem, because this elder son, this caregiver typically thinks, well, I deserve the money because I'm taking care of mom and my siblings are not. So would you exacerbate this problem by saying, well, you get a forced share, and so he would just say, well, I'm taking it now? Or would you alleviate the problem by doing this because he realizes, oh, I will get something when mom dies, so I don't need to take it now, and I can't figure out which way it cuts?
It's an interesting point. Let me take some time, as you will, to figure out which way it cuts, but thank you for raising it.
I just would add that we really know very little about elder abuse in home and community settings as opposed to institutional settings. We know cases that arise, we know the horror stories, and I think we have to be careful saying, you know, that sort of there's a paradigm, a situation. Having spent some time working on issues of elder abuse, I think that your question is a good one. I do think you need to keep separate sort of the mechanisms that society sets up to deal with elder abuse and adult or dependent protective services and the consequences from what we're proposing. And what interests me in what you said is, how do we make sure that an abuser doesn't get an elected chair? That's the part that I think is a very well taken point.
Thanks. My question's for Tom and Josephine's paper also. And the question is, are you at all concerned about the possible federal income tax treatment of the payments, you know, of the forced shares, if they start to look a lot like salary? You know, if it's $1,500 a month for taking care of somebody, you know, normally this would be excluded, obviously, but if it really is designed to look like salary, then I don't know what the federal income tax treatment would be. You could wind up with a situation where something that otherwise, you know, would be exempted under 102 is now not, because it's treated as salary, and maybe there would have to be some tax change associated with the proposal if you wanted to be sure that it wouldn't be taxed.
This issue spotting is very helpful. Thank you very much.
I would say that by putting a lid on the share that could be taken, when you look, I didn't have time to go into this and it wasn't so pertinent, but the value is measured by what the market value would be of the care that a family caregiver is going to, I would think in most instances, far exceed anything that can be taken through an elective share. Not being an income tax expert, I don't know what the effect of that is on the income, but I mean, I don't think they're going to look very much like salaries as measured by what the market value of the care given would be.
Hi, my question is for Tom, or my comment. Jerry kind of hinted at this with the point about the daughter-in-law, but you compensate related caregivers, but not friends. And I mean, there is a sort of a legal duty in certain situations to go to aid in the instance, to go to the aid of a family member, and yet with the friend, it's eleemosynary, and it's not compensated. If I'm a friend and I step up to the plate, I guess the only way I get something is I'm mentioned in the will, and then I'm accused of undue influence. So,
Iris, our view is that this is already a pretty controversial extension of succession law, and as you know, there's nothing in the Uniform Probate Code that provides any sort of succession benefits for friends of the decedent. That was a further step that we were not prepared to go in this proposal.
But just to show you, Gary, that Tom is not quite as radical as you think, I wanted to do what this individual has suggested and finally deferred to Tom's desire not to appear too radical.
And also, I think the statistics that Josie found on caregiving, although it is true that some caregiving is provided by non-relatives, the bulk of the caregiving is provided by relatives. And in one statute, you can only do so much, especially when you're really departing from what the current American law is.
I have two quick questions. One, maybe you mentioned this and I missed it. What if there had been a caregiving agreement during the life where they were actually making payment? There are a lot of family caregiving arrangements where there are payment. The second one, or they have done the classic, put the joint deed on the house. So it's passing outside of probate, but that was supposedly the reimbursement for the party giving the caregiving.
Larry, our statute refers specifically to uncompensated care. So if compensation passes in whatever form, it's outside our proposal.
Oh, okay, fine.
What about the other one?
Pardon?
His second
Joint deed.
the joint deed.
Oh, well, remember the burden is on the caregiver to show uncompensated care. If the joint tenancy is essentially a kind of compensation, the idea that when I die, this is going to be yours, that is compensation.
Bob? Bob Ruffin here.
Two very quick comments. First, for states that do not have an elective right for spouses, this probably would not be very relevant, but there are a number of us like Ohio. But my experience is that this is if there is a problem, this solution doesn't fit, because if the estate, whether probate or otherwise, is very small, there isn't much of an advantage to this. And if the larger the estate gets, you know, there's no problem. If there is a family, close or remote, they'll see that the care is given and that they're the caregiver and that they get the property. And if there's no family, there's no problem hiring all sorts of people. If there's a problem here, it's the problem of undue influence and lack of capacity and new documents and the like. None of which is addressed by this sort of a thing.
There's a great debate about whether or not the spouse's elective share is necessary. And I think this is a debate on which John takes one position and Larry takes another. The spousal elective share has a number of purposes, but a strong one is expressive, right? A success of a spousal elective share statute is not measured by how many times a surviving spouse elects. In significant part, it's measured by how many times a surviving spouse doesn't need to elect, because it reinforces the norm of providing for the surviving spouse through the estate plan. Similarly, our statute, I think, if it were to be enacted, the success of it would not be by how often a caregiver elects, but by how often a caregiver doesn't elect. Similar type of thing. It's the expressive value here to say that this is an example of care and concern within the family, analogous to the reciprocal obligations of care and concern that spouses have for each other. And we signal the importance of that obligation in the spousal elective share, and there's a signaling function here that I would say. Overall, as I said at the beginning of the presentation, the need for family caregiving is huge, and public policy and law throughout our legal system, various bodies of law, are going to need to address this. Neither Josie nor I are saying that the prime mover here is the law of succession. What we are doing in this paper is asking the question, is there a way that the law of succession can make some contribution to this desire to recognize and promote family caregiving?
And this is for Tom and Josie also, and I apologize if we're ignoring you, but during your presentation it was making me think of some of the laws in other countries where we reward the good guys and penalize the bad guys.
I'll see if I can trade with you here.
But I was curious if you considered some kind of a quantum merit concept within this.
Tell me a little bit more about what you have in mind. In other words, some sort of procedure whereby the surviving caregiver could make essentially a claim against the estate.
And for the reasonable value of services and not necessarily limited to a family
Yes.
member.
Yes, no. Unfortunately, the presentation was such an abbreviated part of the article, but as I very briefly mentioned, one reform that we considered but ultimately rejected was simply repealing the rule, which in most states is a common law rule, that family services are presumed to be gratuitous, therefore non-compensable, and just say, well, repeal that rule, and then any family member or anyone who provided gratuitous services can come in during the probate process and file a claim. Our worry, though, is about what this effect would have on norms of caregiving within the family. We're worried about turning non-economic impulses into economic impulses, into turning non-economic actors into economic actors. And that's why we thought maybe doing this in a kind of elective share way might be better, because we don't see the elective share as having the effect of turning spouses into economic actors, but rather it reinforces the reciprocal obligations of care and concern that exist between spouses. So that was why we didn't do the quantum merit or just file your claim in probate, because we don't want to set in process a reform that is going to fundamentally change the way people view these family relationships. We're just very worried about the idea that all these family members are just economic actors and acting out of economic interest. We don't want to go down that path.
Can I also say, back to what I said before, the cost of long-term care now is so great for the bulk of people that receive it. And it's just like healthcare costs, the inflation is out of control. Inflation in long-term care is real costs. It's really out of control. Even if you got by what Tom says was our concern, if you went on a quantum merit, I mean, the claims would be for primary caregivers over any duration of, significant duration of time, would be really enormous in relationship to size of estates, I think.
Question over here.
And so I just wanted to push you guys a little bit about that, and with Jim's point about taxation, and so it may not be full market value, but you moved away from a percentage of the estate to a number. And so I do think there's some market in sort of informing your new model, your revision here. And so I'd love to see in your paper, and I haven't had a chance to read it, some grappling with the fact that you didn't adopt a full sort of creditor model, moved away from the market model because you were concerned about the norms of caregiving and family affection, but you've now moved a little bit to a number which looks like a market model, even though it may not be a full compensatory model. So I think it would be terrific to see some discussion in the paper about that almost hybrid model that you've gone to.
Yeah, and in fact, one reason why I was delighted that Jerry said, boy, I think this number is too low, because I was worried that people were going to say, boy, this number is too high. I deliberately pitched the number low as a way of signaling this is not supposed to be a dollar for dollar return for services rendered, for economic value given, because I am very concerned about that. I think, and Jerry, thank you for making this point, it may very well be that the low dollar figure also helps with another concern, which is what if the caregiver is receiving some benefit through the relationship? Since we're not talking about a full quantum merit recovery of every dollar of care that's rendered, pitching the number low may actually help on a number of fronts. But before we break for lunch, I just want to say thank you to all the members of the audience, and please, as you're traveling home, if ideas come to you, suggestions, please email them to me. We knew that this would be a controversial proposal, and we're eager for feedback.
Hi, everybody. We're going to move across to, that is bright. We're going to move across to the Union now for lunch, and also the presentation by Professor Langbein. So to get to the Michigan Union, what you'll want to do is, I'm sure a lot of people are going to be moving in that direction, so it'll be easy to follow, but you'll want to walk out the State Street entrance of the law school and make a right. And then at the intersection that's right here near the law school, it's a flashing red light. There's another Gothic-looking building on the other side of the street. That's the Michigan Union. And we'll be having our lunch and Professor Langbein's presentation in the Pendleton room, which is on the second floor. So I will see you all over there in a few minutes.